for joining our seminar series. We are organizing in 4 states in the Midwest, and we have folks here from several states across the Midwest and other parts of the country as well, who are working to collaborate, to learn from each other, to build relationships, to build knowledge around strategies that we can take to protect our environment, to protect our water quality, and to fight back against CAFO expansion. And if these terms are new to you, don't worry. Carly and Adam today will be doing some explaining, and I will go ahead and introduce our experts today. So our first expert is Carly Griffith, who is the Water Program Manager at the Minnesota Center for Environmental Advocacy. So Carly and I work together. We're based in St. Paul, but we work a lot across Minnesota, and we've been especially focusing our efforts in the karst region, the karst geology region of southeastern Minnesota. And our second expert today is Adam Voskuil, who Carly and Adam used to work together, and Adam works in Madison, Wisconsin for Midwest Environmental Advocates. So our organizations work on very similar issues with similar strategies. So the contrast here is that we can learn about the regulatory landscape around feedlots in 2 different states today, in Minnesota and in Wisconsin. And we want to hear from folks who are from different states too about what that landscape is like and how we can share strategies between our groups. So today's schedule, we have just 1 hour together today, and we'll hear from Carly for 20 minutes, then we'll hear from Adam for 20 minutes, and we'll have about 15 minutes for question and answer before we leave at 5:00 p.m. So for new folks who are joining, feel free to introduce yourself in the chat. And at this point, I will turn it over to Carly to start her presentation.
Thank you so much for the introduction, Katie, and for all of you who have made time on a Wednesday afternoon to join us on the call. So as Katie said, I'm Carly. I work in the water program at the Minnesota Center for Environmental Advocacy. And, the focus of the talk today is on ways to demystify the regulatory landscape around CAFOs. So I'll talk about some of the different regulatory tools that are used for CAFOs in Minnesota. And we'll get started here with my first slide. Thank you. So first, let's talk about the state of the state. So Minnesota is home to nearly 24,000 feedlots, and 18,000 of those are regulated under the state feedlot rules under the Minnesota Pollution Control Agency. So as you can see on this graph, the number of large livestock operations, which are often characterized as CAFOs, have tripled in Minnesota since 1991, along with an increase in monoculture row crop production and a general industrialization of ag across the Midwest. As you can see here, the largest area of growth in these large livestock operations is swine facilities by far. You can go to the next slide, please. So where are these different CAFOs and large livestock operations? So this is a map not just of CAFOs, but of all 24,000 feedlots across the state. As you can see, many of the swine facilities, which are in the red color, have bled up from Iowa largely. And there's a large concentration of beef and dairy operations in southeastern Minnesota and the central sands of central Minnesota. And these are both areas that are particularly susceptible to groundwater contamination because of the soil types. Next slide, please. So like I said, I'm going to give an overview of several regulatory tools today, which include environmental review, permit requirements, and local controls. And then I'll also talk about some of the issues with each of those tools. So first, I want to talk about environmental review. So here in Minnesota, under the Minnesota Environmental Policy Act, which is our state version of the National Environmental Policy Act, we have different categories where certain types of projects where a mandatory environmental review must occur. And the first step in that process is through what's called an environmental assessment worksheet. And the purpose of the environmental assessment worksheet is to assess whether a full environmental impact statement is needed for a particular proposed project. So here in Minnesota, an environmental assessment worksheet is required for the construction or expansion of a feedlot with 1,000 animal units or more. And an animal unit, as I'm sure many of you are aware, is a measurement based on the amount of manure produced by an animal, and it varies by animal types. And then mandatory environmental assessment is also required for feedlots of 500 animal units or more if the facility is located in sensitive areas such as floodplains or near karst features like sinkholes. However, the environmental assessment worksheet, like I said, merely assesses if a full environmental impact statement is needed, and those do not often occur. The Minnesota Pollution Control Agency often does not require a full environmental impact statement. And the environmental assessment worksheets themselves also do not need to identify project alternatives. That only happens with a full environmental impact statement. And until recently, they did not need to account for greenhouse gas emissions either. But recently there was advocacy from MCEA and other organizations pushed the Environmental Quality Board in Minnesota to include questions about climate impacts in the environmental assessment worksheet form. So that's a good step forward for us. Next slide, please. So environmental review looks at the environmental impacts of a proposed action, but what ultimately regulates feedlots is state and federal permit requirements. So that's what I want to spend some time on here. In Minnesota, there are two primary permits that apply to feedlots: the National Pollution Discharge Elimination System, or NPDES permit, and also the State Disposal System permit. So both permits regulate the storage, transportation, and use of manure and are administered by the Minnesota Pollution Control Agency. The NPDES permit is a federal permit under the Clean Water Act, but has been delegated to the state to administer. So let's talk about NPDES first. Federal CAFO regulations stem from the 1972 Clean Water Act, which creates a distinction between point sources, which are discrete conveyances to surface waters, think of things like a pipe, and non-point sources, such as stormwater runoff. Most areas of agricultural activity are exempted as non-point sources from regulation under the Clean Water Act, but feedlots are one of the few areas that is regulated as a point source if it reaches certain thresholds. So for feedlots, they require a NPDES permit if it meets one of the federal large CAFO thresholds and discharges to waters under federal jurisdiction. And by discharge, I mean directly adds a pollutant to those waters. There are both individual permits in the NPDES program where site-specific information is part of the application and the permit review. And then there are also general NPDES permits. These are much more common, where multiple dischargers obtain coverage under the general permit if they meet the permit eligibility terms. And then the state disposal system is a Minnesota permit system, which is required for any facility with 1,000 or more animal units. So both of these permits are intended to control the release of animal manure or manure-contaminated runoff from manure storage or feed storage areas. These are what is called production areas, and then also from land application sites where manure is land applied. The primary way these permits control those discharges is through construction standards for manure storage areas and requirements to do visual inspections of production areas to ensure that there are no leaks. However, leaks do occur, as you can see in the picture on this slide of a manure containment structure that has leaked. Next slide, please. So I want to talk a little bit more about land application. So The other primary tool of these permits is to require facilities to follow a nutrient management plan to direct not just how manure is stored, but also how it is land applied on crop fields. These management plans lay out best management practices such as site-specific conservation practices and appropriate agricultural utilization of nutrients. However, there are a few guardrails to ensure compliance with these best management practices. Under the NIPDES permit that I discussed on a previous slide, a nutrient management plan assures that a discharge related to land application activities gets an exemption under the agricultural stormwater exemption in the Clean Water Act. So if there's a discharge or runoff from a heavy rainfall event, that's exempted from regulation under the NIPDES permit. And I want to highlight that land application areas are really one of the roots of the problem, because this is where both chemical fertilizer and manure is land applied for crops. So there is a higher probability for nitrate to leach into the groundwater and contaminate water supplies. MCEA, here in Minnesota, MCEA and other clean water organizations have highlighted the need for a few more protections on land application, and I want to talk about a couple of those briefly here. The first is broader seasonal fall restrictions on manure application in sensitive areas where the groundwater aquifers have a high vulnerability to contamination, because when there's fall application on bare ground, up to 40% more nitrate can leach to the groundwater. And you can see that in the image here. And then another issue that clean water organizations have highlighted is that there needs to be a broader prohibition of land application of solid manure on snow-covered and frozen ground in sensitive areas, because if you apply manure on snow-covered or frozen ground, it just runs off and doesn't do anything for your nutrient management. Next slide, please. So I want to talk a little about compliance and enforcement. And the question here is, in Minnesota, how do we ensure compliance with these nutrient management plans? So in the map on the left, you can see that there are 15 staff in the Minnesota Pollution Control Agency feedlot program, and they are responsible for compliance and enforcement across all 87 counties in the state. As you can see in the map on the right-hand side, there are also what are called delegated counties, which administer the state feedlot rules and regulations within their county for smaller feedlots, usually less than 1,000 animal units. And the Minnesota Pollution Control Agency oversees larger feedlots in delegated counties and all feedlots in non-delegated counties. So as I mentioned earlier, the Minnesota General NIPDES permit does require visual inspections of the production areas where the manure is stored, usually self-reported by the producer. So the feedlot operator will do visual inspections and report them, but there are occasional inspections by a state or county feedlot officer also. And I want to highlight some of the aspirational goals for how often those state or county feedlot officer inspections occur. And I want to emphasize the fact that these are aspirational, and in many cases, these inspections happen less frequently than the goal. So the goal is for inspection 2 times every 5 years for facilities under the general NIPDES permit. And for county feedlot programs, the goal is inspections for 7% of the registered feedlots in the county per year. So this means that in delegated counties, which are often the same counties with a high density of feedlots, inspections may only occur sometimes every 10 years. So really infrequent inspections by a state feedlot officer. Next slide, please. So another issue here is, what about actual data? In addition to these in-person inspections, what about actual data to ensure compliance with the permit terms? And this has been an issue that has gotten more and more attention in the past 10 years. So the Clean Water Act and Minnesota rules require that permits prescribe conditions such as monitoring and testing to determine if there is compliance with state and federal pollution control rules. However, neither of the Minnesota permits, the NIPDES or the SDS permits, require groundwater monitoring in production areas or land application areas to ensure that discharges to groundwater do not occur. So recent legal challenges in other states have focused on the need to actually monitor discharges to ensure compliance with the permit. So one example is in Idaho in 2021, Food and Water Watch, which is a national organization, challenged the state's general NIPDES permit for CAFOs. And the US Court of Appeals for the Ninth Circuit ruled in their favor that the permit, quote, lacked sufficient monitoring provisions to ensure compliance with the permit's zero discharge requirements for both production and land application areas. And just as a brief foreshadow here, I think Adam will have more for you on this topic in Wisconsin. Next slide, please. So I want to, to make this a little bit more tangible, I want to focus briefly in on one region of the state, which has high susceptibility to groundwater pollution, and also highlights the fact that it's really difficult to have these one-size-fits-all rules for the state when there's a lot of variation region by region. So the region I want to focus in on here is the karst region in southeastern Minnesota. In Wisconsin, it's the driftless. This is a region with a really high density of feedlots of different sizes. So the ones in that green color are registered with the state, but don't have any permit requirements. The ones in the orange color have a NIPDES, and in some cases, both a NIPDES and an SDS permit. And the ones in blue have just the SDS permit. So, a big part of this problem here is not just the fact that there are these issues with the permits themselves, but also the fact that in some parts of the state with a really high density of feedlots, many of the feedlots aren't regulated through a permit. If a feedlot is over 300 animal units, they are supposed to have a manure management plan under Minnesota rules, but they don't have to actually submit it to a regulatory agency unless an agency requests it. And these smaller feedlots often don't have the same manure storage capacity as the larger permitted CAFOs. CAFOs are required to have manure storage for 9 months under the NIPDES permit. So these smaller operations are more at risk for emergency manure applications at times of high runoff risk, just because they run out of space to store the manure, which is extremely expensive to increase manure storage capacity. Next slide, please. So briefly, the reason why this region is more vulnerable is to groundwater contamination from nitrate, which comes both from fertilizer and manure application. There's a thin layer of topsoil and porous water-soluble bedrock that gets these fractures in it that the surface water can travel into the groundwater aquifers through. And then karst features like sinkholes. And all of this means that surface level contamination can quickly infiltrate the groundwater and pose a public health risk to the water supply. So in this part of the state, both private wells and public water supplies draw from groundwater. Next slide, please. And in fact, there has been widespread contamination of both public and private water supplies. So in the 8-county region that encompasses most of the karst in Minnesota, nitrate levels in both private wells and public water supplies routinely exceed the federal drinking water standard of 10 milligrams per liter, which is intended to protect against blue baby syndrome and other public health impacts like an increased risk for various forms of cancer. I want to add a little nuance to this data for you to paint a clearer picture. So in Fillmore County, which is in the bottom center of this map of 8 counties. If I had a pointer, I don't have a pointer, so I'm trying to point at my screen and I'm realizing that is not helpful to you. But in Fillmore County in 2018, the Minnesota Department of Ag tested private wells across the state, and 17% of the private wells they tested in Fillmore County were above that federal standard. And I want to highlight the federal standard is 10 milligrams per liter to protect against blue baby syndrome, but recent research has shown human health impacts at much lower levels, as low as 3 milligrams per liter.
Carly,
Then to
time check. So just to try to wrap up in about 3 minutes if possible.
Okay. And then in Winona County, 19% of private wells tested above the federal standard. And if you get at the township level, 2 townships in Winona County, Utica and Fremont, show that over 50% of private wells tested over a 10-year period were above the federal standard. So clearly, we're at a public health crisis at this point. Next slide, please. So I want to briefly touch on local controls, and one of those examples in Minnesota is cities, counties, and townships can set animal unit caps and/or require conditional use permits in local zoning ordinances. This is most widely used in southeastern Minnesota in that karst region that I just showed you. I just talked about water quality in Winona and Fillmore counties, so let's dig into those places more. In Winona County, conditional use permits are required over 300 animal units, and the animal cap is 1,500. But that local animal unit cap has been under pressure. So there's a picture here of Mr. Daly, who runs Daly Farms in Winona County. And Daly Farms requested a variance from the 1,500 animal unit cap so that they could increase their operation to 6,000 animal units. So more than triple the animal unit cap. The Winona County Board of Commissioners turned down that variance request, not once, but twice. And Daly has since filed a lawsuit in Winona County District Court against specific members of the Winona County Board of Commissioners, as well as members of a local advocacy group, on the charge that they deprived dairy farm operators of their constitutional right to be heard before an unbiased governmental body. In Fillmore County, the animal cap has been 2,000, but by unanimous county board vote in February 2023, that animal unit cap was doubled to 4,000. Next slide, please. So in addition to the pressure on local controls like these animal unit caps, there is also diffuse agency authority at the state level to address the nitrate groundwater contamination problem. This means it's easy for one agency to say, well, we just have jurisdiction over this one part of the problem. And it means that no one addresses the full scope of the problem. Next slide, please, so I can wrap this up. I think if you go back one, there's one more. Yes. So to address this problem of diffuse agency authority and call for broad scale action to address this public health crisis, in April 2023, MCEA and 10 other environmental organizations petitioned the Environmental Protection Agency under the Safe Drinking Water Act to use its emergency authority to intervene and investigate nitrate contamination of drinking water from industrial agriculture in the karst region. And I'm happy to talk more about this petition in the Q&A. In the next slide, I outlined some of the requests that we made. If you can advance one more slide, please. Some of the requests we made to the EPA in the petition. And then the final slide, if you jump ahead one more, is some of the next steps, both for the EPA's review of the petition and actions that we'd like to see local government officials and state agencies take to address the problem. So I think I'll leave this to discuss more in the Q&A if people are interested, and hand it over to Adam.
Thanks, Carly. It goes fast, these talks. And so with that preface, I will try to also run through this stuff really quickly, but coherently. And just a reminder, I believe Katie said it at the start, but feel free to start throwing questions in the chat and we can address them at the end of the call today. So as Katie said at the beginning, my name is Adam Voskuil. I'm a staff attorney at Midwest Environmental Advocates. We are based in Madison, though today I am joining you from Chicago, where I attended a seminar that also looked at multi-state CAFO issues in other Great Lakes regions. So just kind of interesting. It's on the mind of a lot of folks. Next slide, please. So MEA is a law firm, and we practice primarily in Wisconsin, though we have, in some limited respects, extend onto the broader kind of Great Lakes region. And we tend to operate under a community lawyering or a scaffolding approach, where we're representing communities. We're trying to support their work, and we're guided by their goals, both in in specific legal actions, but also kind of in advocacy and support as well. And that manifests in litigation, in advocacy, in providing resources and outreach and attending events like this as well. Next slide, please. So Carly got into this a bit, or pretty comprehensively. I'm not going to address a lot of the Clean Water Act at the federal level. So Wisconsin has a delegated program under the Clean Water Act, which means our state Department of Natural Resources is actually the regulatory body that implements the Clean Water Act, and they do so by issuing permits to CAFOs. And so I am primarily going to focus this talk today on the state level and then the local level as well. Next slide, please. So to give a bit of background, and I'll flag I don't have as fancy of maps as Carly. I'm a touch jealous, but in Wisconsin, we have about 327 CAFOs. That's to some extent subject to change via consolidation of some currently existing CAFOs, but also some CAFOs, emerging over the last year or two when I found that number from purchasing of smaller family farms. And we've really seen that proliferation of CAFOs shoot up dramatically in the last, say, 20 years. And I will note that that increase in number of CAFOs has not necessarily corresponded to an increase in the staff at the state's Department of Natural Resources that's meant to permit these and review them and inspect them, which has led to some regulatory gaps. And you can see, if you look at the map on the right, that proliferation of CAFOs is not equally geographically spaced. So I want to focus, or to some extent, MEA has focused in large part on a few different areas of the state where we're seeing consistent problems, as well as outreach from communities as well. So in the northeast corner, and by northeast I mean kind of that thumb, Kewaunee County, Door County, Brown County, where Green Bay is, that's a place characterized by karst geology, which Carly mentioned as well, fractured bedrock, while also being shallow depth to the water table as well. So you can see a kind of easy transport of water to those areas. And that karst, not that exact karst, but karst geology exists kind of making a horseshoe ring from that thumb down to the base of the state and then up the western side of the state as well. And so if you think about that 8-county region that Carly had in her map, you can see just on the other side in Wisconsin, there are similarly a large number of CAFOs, and with them a significant number of environmental concerns flowing from their existence. And then so in addition to those two portions, the other place that MEA is focused, or kind of that singular karst region, the other place that MEA is focused is in the center of the state, where, unlike the karst regions, there's sandy soil that's similarly allows for easy transport of contaminants down to the water table, which then move to people's private drinking water wells. Next slide, please. And so, just to step back and recognize, right, the CAFOs pose a lot of threats to communities. Certainly, there are folks on the call that are already aware of a lot of these concerns or threats, and similarly may experience them. But the regulatory authority imposed by EPA, or in Wisconsin, the DNR, is largely limited to, it has a water focus. So the EPA, if they were the ones administering the program, would be focused on waters of the United States, which would mean that permits would largely focus on surface water contamination and degradation. In Wisconsin, we have a broader definition of waters of the state that includes groundwater as well. So our DNR permits address surface water contamination, groundwater contamination, and then by extension of that, drinking water contamination of private drinking water wells for folks that may live adjacent to or down gradient from a lot of those CAFOs. However, air quality decline, diminished property values, increased truck traffic, a whole host of other concerns. I could think of mortality management or concerns related to infectious disease outbreaks. Like those things are not explicitly covered by our state permitting program, but we have seen attempts by local communities to kind of fill those regulatory gaps, particularly in recent years, and I'll touch on that towards the end of this talk. Next slide, please. So that really shifts us into what does our DNR do when they're issuing permits. Unlike Minnesota, that has kind of that two-tiered, that NPDES and that SDS permit, there is one permit that is issued to CAFOs. It's called, we call it the Wisconsin Pollution Discharge Elimination System permit, or colloquially, the WIPDES permit. And let's see, just to make sure I'm not skipping ahead too far. That permit will contain things like restrictions on discharges, requirements for a certain amount of storage. You have to have in Wisconsin 180 days worth of storage for all of the liquid manure and processed wastewater you're producing. It'll have some sampling requirements and compliance schedules, but a lot of it is boilerplate. So although Wisconsin is issuing individual permits to each CAFO that is applying, if you were to put two permits right next to each other, in large part, you would see very similar, if not the exact same language between both of them. Next slide, please. But that doesn't mean that there's not an opportunity to shift or alter how those permits function or the requirements therein. And that really starts with getting to understand what the underlying data is that is supporting DNR's decision to issue that permit, and then really pushing on inadequacies. So I really like focusing on this slide to let people know that, when the initial draft permit comes out, it can sometimes take people by surprise, but the permit application actually comes in 180 days or somewhere around 180 days or 6 months before the actual issuance of the draft permit for public review. And that permit application is available online. Now, I'll note that it's not publicly advertised by the Department of Natural Resources that it's been, that they've received that documentation. And so, people may still find out late. Certainly, I'm not everywhere at once, so I tend to find these things out late. But for folks that may hear rumblings about a CAFO coming into a community, there is a resource online that you can find a lot of this information. And so they have things like the Environmental Analysis Questionnaire, which is going to be really similar to the Environmental Analysis Worksheet or Environmental Assessment Worksheet that Carly mentioned. The CAFO will also be submitting a nutrient management plan. And in recent years, they've actually included the actual database and spreadsheet and things that you can upload to a program online to see all the fields that they're spreading on. It'll include discussions of engineering specs for the monitor or the manure lagoons and the storage and animal feed pads and barn type engineering specs too. So it's relatively comprehensive. And I think one of the first steps to being able to be involved in this regulatory process at the, as someone that may be affected by the decision by the DNR is to find these documents and start reviewing them. If you could jump to the next slide, please. And that's because, as I kind of prefaced a couple slides ago, the comments that you provide do have an opportunity to shift the terms in a permit, right? So over the last few decades, we've seen consistent research showing that there is contamination of drinking water, private drinking waters and private wells in Wisconsin. So I grabbed one picture here, and that's kind of a snapshot of nitrate contamination in Wisconsin. Nitrate is Wisconsin's most pervasive groundwater contaminant. it is growing in severity and frequency that it's being detected. And over 90% of it is attributable to agriculture. And that's based on our DNRs. Annually, they put out a groundwater coordinating council puts out a report. And so that's been regularly reiterated by the department. And so, and you can look at similar maps of bacteria that are, startling in other ways, of showing where the high frequencies of bacteria, E. coli or coliform, are being detected in private drinking water wells. And so it's kind of with this backdrop, with this understanding that groundwater contamination, particularly attributable to agriculture or less agriculture and more specifically concentrated animal feeding operations for my purposes, we presented that to the Department of Natural Resources and have been for over a decade now, if you can jump to the next slide, and demanding that they do something about that contamination. So this was kind of the slide, the groundwater monitoring issue that Carly foreshadowed. And so in 2011, so 12 years ago now, Midwest Environmental Advocates representing a number of residents of Kewaunee County, so up in that thumb that I mentioned, challenged a CAFO permit demanding that there be groundwater monitoring on the land spreading of fields, something that had not been done in Wisconsin to date. And we pointed to our statute that says that the Department of Natural Resources is empowered to include terms in a CAFO permit that are necessary to assure groundwater standards. And so we said, we can't know if this CAFO and their practices are causing exceedances in groundwater standards without groundwater monitoring. We have a great belief that they do, but DNR is not going to take the next administrative action of bringing enforcement action or taking fields out of rotation until they have that clear data that's showing this field, this actor is causing this contamination. And so we said, based on the depth to bedrock, the sinkholes that exist in the area, the significance of fractures, and the high percent of groundwater contamination, private drinking water contamination in Kewaunee County, DNR needs to start regulating these and requiring groundwater monitoring. That case was decided by an administrative law judge in 2014, where he called the groundwater quality crisis a massive regulatory failure. But it didn't stop there. We had a collection of appeals and weird procedural quirks that ultimately delayed the case and the decision as it progressed to our state Supreme Court. And then finally, 2021, 10 years after we initially brought the contested case hearing, the Wisconsin Supreme Court affirmed that authority. They said DNR does have the authority to include those terms like groundwater monitoring that are necessary to assure compliance with groundwater standards. And I think, we're seeing more and more of that. Carly mentioned Idaho. Colorado had a similar decision based on a CAFO general permit, I believe, as well. So there's a growing recognition that monitoring is necessary for these practices to ensure that they're not just contaminating groundwater without anyone being aware of it or being able to step in. All right, if you can go to the next slide. I'm going to kind of round out, recognizing time, going to round out and say that I'm happy to talk more about the WIPD's permit process. We have a guide that we published that also talks about it as well, but I want to jump to local decision making with my remaining time. So there are a few different ways that we see the regulatory framework play out for CAFOs at the local level. And historically, over the last 20 years, the most prominent one has been livestock facility siting. So if you look at this map, livestock facility siting is this set of default standards, baseline standards that can be adopted by a local government, either a county or a town, and it can function either as a licensing ordinance or a zoning ordinance, and it largely doesn't matter which plays out. But on this map, the red would be the zoning ordinance. Red is licensing, sorry, apologies, and green is the zoning ordinances. And the smaller kind of brighter squares would be the townships that have enacted them as well. And then just for anyone interested, the yellow circles are animal feeding operations that are below the 1,000 animal unit threshold that have applied for permits under that livestock facility siting regime as well. Next slide, please. So the livestock facility siting law was passed in, I want to say 2004, and its purpose was to provide uniform regulation of livestock facilities. And so, like I said, it created these default standards. It addresses odor and air setbacks, nutrient management plans, property line and road setbacks, manure storage facilities, and production site runoff. And it basically says that the local government can adopt or opt not to adopt these standards, and give the government a choice whether or not to adopt them. And in large part, they've only been adopted, governments have only adopted those default standards. However, if you want to jump to the next slide, I do a lot of this transitionary discussion. There is a carve out in the language of the statute that does provide for more stringent standards. Now, I've rarely seen it used. There's a lot of industry pushback whenever a local government attempts to adopt it. But looking at the right side of this chart, you can see that under livestock facility siting, a local government has the authority to adopt more stringent standards that are A, necessary for public health and safety, and B, supported by scientific findings of fact. So there's kind of this two-part test that exists. However, there's not any additional guidance beyond that. What makes something necessary for public health, or whether the scientific fact needs to be specific to the geographic region, whether they need to produce their own study or they can use studies from other areas that they can incorporate because of similarities in kind of their geographic or their topographic or geologic fact patterns. And so because of that gray area, the industry groups have historically threatened litigation to local governments and pressured them to keep them from adopting more stringent standards. But MEA has supported those local governments along the way. We've provided models for what certain standards could look like, and written letters pushing back against local government or pushing back against industry groups when they receive those threatening letters. I have 2 more slides left, and I just want to jump out of livestock facility siting to a different form of local control that we've seen over the last 2 years play out, and that is a CAFO operations ordinance. And so this is different than livestock facility siting, where you're regulating the siting, the location of a livestock facility. And instead, we're talking about how the day-to-day CAFO operates. And so 5 towns up in Northwest Wisconsin, in Polk and Burnett counties, the towns of Sterling, Laketown, Trade Lake, Luck, Bone Lake, and Eureka created the initial kind of framework for this. And then 5 towns adopted what was the ultimate operations ordinance. They basically created a long list of findings of fact explaining the need and the justification for these more stringent ordinances that address things like mortality management, air pollution, property values, drinking water and private well protection, traffic concerns, just this whole host of other issues, and why they were necessary. And then they passed a licensing ordinance. They each individually passed a licensing ordinance that are on the book now in 4 towns up in Northwest Wisconsin. That was challenged. One of the towns, their ordinance was challenged by an industry group, but ultimately the case was mooted out because the town board rescinded following an election where the politics of the town switched. The town board rescinded the ordinance and mooted out the case. But 4 of the towns still have those ordinances on the books, and MEA is continuing to support folks up there and the towns up there. And we're hoping to see more adoption of CAFO operations ordinances across the state as a kind of relatively new regulatory framework that can be used. So final point that I'll make, last slide, is that there are ways to get involved at the local level, whether that's through pressuring your town boards, starting sampling or testing programs, which also include kind of monitoring if there already is a CAFO in the area, and just asking questions, making open records requests, kind of demanding that there be transparency both at the local level and at the state level, and really pressuring folks to explain their reasoning and justify with what we would argue needs to be sound science, why a permit is being granted or why an ordinance is or isn't being passed, because they're supposed to be protecting the constituents and the communities across Wisconsin. So like I said, we have a guide that was sent out. Feel free to reach out, go to our website, and you can contact me or anyone else at MEA, and we'd be happy to help you. But I think I will turn it over to questions.
Thank you, Adam. Thank you, Carly. Everybody join me in a virtual round of applause for our experts who are fabulous resources on, yeah, a really complicated issue. And so this, the purpose of this seminar is for folks to get together, to be able to collaborate and to understand, build a shared analysis around these issues. I loved both Lee and Zach's questions in the chat, so I want to prioritize that. Lee, if you wanted to come off mute and share your question.
Yeah, so I've heard people say, like, hey, if we do more regulation, these farmers that are doing their best are going to be hurt. They're going to have to make investments that we'll put them under, This is what I've heard, and I've thought, well, like, do we know what the long tail is in terms of, like, hey, a whole bunch of little farms in a distribution, okay, it's skewed, and there's all kinds of little farms that add up to something significant. And so we maybe need to do something. How do we, or can we, like, design or use regulation in a way that we can make the problem better, but not, kind of not drive them out of business, right? Or not make them go toward, it might actually, like a lot of unintended circumstances, maybe they become a CAFO because they don't know how to make it. And so how do we creatively regulate, or,
That's a really good question, Lee. And one thing that I want to say here is that if you propose solutions that then you run into barriers for widespread adoption of them, then that's not a full solution. So one example of this that I will give is, in Minnesota, we have a groundwater protection rule that was passed by the Minnesota Department of Agriculture in 2019. And what that regulates is not manure land application, it's focused on chemical fertilizer application. So what they've done is they have a fall fertilizer application ban in sensitive areas of the state where there's already a high amount of groundwater contamination from nitrate. So, if we were to have a similar ban in place for manure application, we would want to think through that issue that I highlighted, that many of the smaller and mid-sized feedlots might not have the same manure storage capacity that the larger feedlots have, and also recognize the fact that manure storage capacity is incredibly expensive. So would you maybe be able to pair, like, say, the agency said 5 years from now, we will mirror the fertilizer fall ban in sensitive areas with the manure ban, fall application ban, but to help get us ready for that regulation in 5 years, here's a grant program that can help smaller operators increase their manure storage capacity. Because we do have some new sources of money, for example, under the Inflation Reduction Act, to try to get at some of these problems. So that's one example of a way to try to think creatively about the barriers that a proposed regulation would face, and then how can you think about meeting those barriers?
I like that. Grants would be great. And why, in my initial thinking, it's like, why wouldn't we want to regulate both? And with a grant, if we can make it, it does seem to care about the small farmer. Thank you.
Thank you for the question.
So Adam, you could respond to that too if you want to. Otherwise, we can turn to Zach's question.
I think Carly did a great job. The only thing I would note kind of additionally is the DNR, sub 1,000 animal units, our DNR doesn't have really much of any regulatory control. So when, depending on your definition of small farmer in terms of kind of the regulations that would put them out of business are relatively limited at the lower threshold level. But that doesn't mean that those folks aren't, couldn't find grants. Although I did see in the comments this concern about how the bigger CAFOs tend to have more resources available to them in terms of experts and folks assisting them, which I think also carries over to being able to find more kind of federal funding, say, or opportunity for financial buy-in from outside interests in a way that the smaller farms, because they don't have that same those resources available to them to find those opportunities, are similarly limiting. And unfortunately, because I'm an attorney, a lot of my work is on the back end once the contamination occurs. So I don't have a great answer to how to kind of fix it on the front end just yet.
Mm-hmm. Yeah, and our third seminar actually will be on alternative solutions. So we'll be focusing on the farmer side and, you know, what farmers are proposing and what they're doing really to counter the polluting factors of large scale farming. So Zach, would you like to ask your question?
Yeah, sure. You mentioned both mentioned the thresholds as far as the animal units and how that triggers certain regulation. What we're seeing in Kansas is that the bigger farms are starting to divide into smaller LLCs to get to those lower animal unit thresholds and thus not have as much regulation. So my question was about, is there a way that we can define a regulation or provide some proactive restriction on CAFOs per the watershed as a collective way? So if you have so many CAFOs in a certain area, you can't have any new ones or expansion, that sort of thing.
Yeah, so I would love to take this one first, Carly, but I can kick it to you because I think the local governments have a lot more authority in, or have already used kind of this similar thing in Minnesota for at least putting caps on things. But I mentally divide your question into two parts, one of which is the subdividing into LLCs, kind of these smaller, trying to meet lower thresholds. And you know, the one thing that I can say is, at least in Wisconsin, and I would wonder if it exists in other states, but our department has the ability to consider separate sites that may have co-ownership or shared equipment as a singular entity for terms of permitting. So at least that in that respect, there may be a regulatory fix that is as simple as consideration of based on co-ownership. And I think that those regs are mirrored in either EPA regulation or guidance, co-ownership and similarly shared equipment as reasons to consider the ultimate facility or operation as a single entity for permitting purposes. Now, as it relates to animal unit caps in a particular watershed, so that 2021 Kinner decision that we had, similarly, our Wisconsin Supreme Court affirmed our Department of Natural Resources authority to set animal unit limits. And since then, they weren't really explicit on what the DNR needed to base that off of. And so we've been pushing since then on regional or watershed, you know, capacity thresholds are met. For Kewaunee County, we haven't needed to do or have focused less on watershed and just noted the fact that it's on a peninsula and there's not any more land to spread manure on, and they don't have the money. They couldn't afford to ship it far out enough to be able to sustainably spread waste anymore. It has had mixed effects on our regulators, but you know, it's something that we've started pushing for. We're probably only a year advocating for that really aggressively, maybe two, but something that I imagine we will continuing to push because, as you know, like, you know, you will reach either ground capacity or watershed capacity thresholds, and really the DNR should be starting to consider, or whatever regulatory authority should be starting to consider, like what one more on top of that's going to look like for the ecosystem as a whole.
And I would just briefly add to that, you know, two tools that we have in Minnesota. The first has not been litigated in the context of feedlots, but the Minnesota Pollution Control Agency is supposed to, in their the statute that authorizes them, that gives them their agency authority, they are supposed to consider the cumulative impact of permits in their decision. So that has been litigated in the context of groundwater quantity in an area called White Bear Lake, but it has not yet been litigated in the context of feedlot permits. But to see if there's a similar tool in Kansas. And the other thing that I would say is, so I mentioned the environmental impact statements, which don't often occur for individual feedlots, but there was a time, so I'm sure some people on this call remember the fight around the Catalpa farm, which was a huge proposed hog facility in the karst region that I discussed of Minnesota, where their permit was denied by the Minnesota Pollution Control Agency, and the agency commissioner at the time said we should do a regional environmental impact statement of the impacts of animal agriculture in the karst region. That never happened, but that is another tool that could be used to look more at regional or watershed-wide impacts.
Okay, well, I know we have just a couple minutes left. I did put the link to the next panel, which is next Wednesday. So please join us again next Wednesday at 4. But before we depart, I did want to ask Kim to ask your question, and we'll have that be our closing question today.
Yeah, what I find really frustrating is that when there are TMDLs, especially for phosphorus, like for the St. Croix River and other rivers in the watershed, why is that not playing a role in any of these decisions? What does it take to get that to change?
So it's this weird, it kind of comes to the point of non-point source, and the idea that while CAFO production sites are point sources, they are no discharge point sources, that kind of where the manure lagoons are, and the spreading fields, any wash off from that, the argument is that those are non-point sources, and TMDLs are explicitly meant to regulate point sources. I will be honest, it's not just a question that we've been grappling with, but also one that, like, one, it logically doesn't make sense, and two, I think as we're starting to see courts like Idaho and Colorado point out that you can't just rely on what was called like the agricultural stormwater runoff exception. This idea that like the only time pollutants are running off fields is when it rains, and recognizing that contaminants like phosphorus may get off fields if it's spread in liquid form, or if it's overspread, or if there's drain tillage. And so I think we're seeing, or we're hoping to see more and more folks, at the regulatory level, think about whether or not there's a way to incorporate non-point sources, they define it, into TMDLs, but it's just been something that hasn't happened. And the second that it would happen, it would be litigated up to a court of appeals, if not, the Supreme Court, just because of its kind of novelness and the language of non-point source versus the definition of a TMDL. So it's just kind of because of this legal fallacy that stuff that's spread on fields doesn't wash off unless there's an agricultural or a rainfall event, and anything else, if they're complying with an NMP, they're probably not discharging.
Yeah, I just want to piggyback on that quickly. We use a very similar term, Adam. We talk about the legal fiction of these permits, that if you follow the terms of the permit, there will be zero discharge. And if there is discharge from a heavy rainfall, that's exempted, right? So it's this circular logic. And I really like what Adam said, that, this push across the country for more groundwater monitoring to actually test that legal fiction with some data to check for, dry weather discharges from both production areas and land application areas is a really good step forward. Also some states have tried to look at this idea of drain tile, which is, if you look at the definition of a point source, it's a discrete conveyance to surface waters like a pipe. Drain tile seems to fit that definition in many ways. So some, Iowa tried to litigate this, the case didn't advance, but other states may start to, challenge certain areas of these non-point source definitions to see if they really apply.
Doing this at the library.
Okay, it sounds like we have some, follow-up topics to keep discussing as a group here, and lots of good ideas coming out of this conversation. So I feel great that we achieved the goals of this seminar, that folks from different regions and states are generating ideas together about regulatory tools and strategies. So we will close this session for today and hope to see you next Wednesday at the panel discussion on positive alternatives to the CAFO system. And thank you all so much for being here, especially Adam and Carly.
Thank you
Thank
so
you.
much.